Hey yo folks, and welcome to a bit of an update before tomorrow's stream on the Young Thug trial hearings this week. You might have seen the thumbnail, and it's just a little bit clickbaity, but it kind of is a strong possibility if the judge grants the defense motion to disqualify Miss Love, or to remove Miss Love because she made herself an unsworn witness. So, Fani Willis wrote the response to the defense motion to have Assistant District Attorney Love either removed or filed for a mistrial. And Fani Willis wrote that response. So I'm just going to go through it real quick. Well, as quick as you can do. As quick as you can do. Let's see here. Dun, dun, dun. Oh, I'm so good at this. Add to stage. There it is. And let's do one of these. Or this. Yeah, no. No. Let's try this one. Or this one. But it doesn't matter. Okay. Let me bring this a bit bigger. Can you still see it? Yes, you can. Okay. In the Superior Court of Fulton County, Georgia, State of Georgia v. Jeffrey Williams, indictment, blah, blah, blah. State's response to defendant Jeffrey Williams, April 1st motion to disqualify. The state, by and through its counsel, Fani T. Willis. So, Fani Willis decided, hey, I know a bit about disqualification. Let me write the response to this. Now, she kind of has to, but it's very, very ironic. And this is because she's Miss Love's boss. So she is the one who actually has to write this response. District Attorney for the Atlanta Judicial Circuit and the undersigned Chief Deputy District Attorney hereby responds in opposition to defendant Jeffrey Williams' motion to disqualify. In support of this response, the state shows as following. Introduction. The credibility of the undersigned prosecutor is not related, let alone central, to this trial. Credibility is always an issue in a trial. Central? No, if you have good enough evidence, then you can have a poor prosecutor presenting it. But in this case, I say from the heart, credibility of the prosecution is central. So I don't agree with that. Because the jury knows what the lawyer says is not evidence. Somewhat true. But that applies most on opening statement and closing statement. And in this case, Ms. Love interjected herself and conversations she had with the witness, Miss Bennett. So, yeah, what she claimed was part of the discussion is now entered into record and is evidence. So I say this is completely wrong. She continues, there is no need for the undersigned to be called as a witness since she is not the only person present for the communications with the witness in question. Doesn't matter. One bit, in my opinion. Williams' constitutional rights are intact, as are the rules of professionalism. I would disagree there. Williams' motion smacks of political theater and histrionics of the worst variety. You are the one to say that, Miss Willis. You are the one to say that after the stunt you pulled in your own disqualification case about histrionic. Yeah, that's a lot. That's a lot coming from you. Even assuming arguendo that the law he cites is germane, which is not. Seriously. Disqualification would not apply under these circumstances. Very simply, Georgia law does not entitle Williams to the extraordinary remedy that he seeks. Williams' motions must be denied. Now, this is just the introduction. Here comes her first argument. The undersigned prosecutor has not become an unsworn witness. Contrary to Williams' assertions, the undersigned has by no means become an unsworn witness in this case, and Williams provide no compelling authority for the proposition that her disqualification is required. Well, she kind of has to say that. I don't agree with it, but ultimately it's up to the judge to decide. In fact, the only supposedly on-point Georgia case cited in Williams' motion, Chambers v. State, yeah, that's the Georgia case, but they cited federal cases, Supreme Court decisions. That kind of has bearing. You don't wanting it to be on point doesn't make it not on point, Miss Willis. She claims, is so wide off the mark that only under the most tortured interpretation can it be said to apply here. Okay. Chambers, to begin with, is a juror misconduct case where a verdict was tainted because a juror did independent research. Importantly, the prosecutor in Chambers was not disqualified, nor was this even an issue in the case. I don't care. Because this Chambers v. State is one of the lesser cases they cited, and for not the reason Ms. Willis claims. Williams attempts to artfully weave into his discussion of Chambers the idea that in improperly doing independent legal research, the juror became an unsworn witness against the criminally accused. Yeah, but that is just saying unsworn witness. Independent legal research in this case would apply to Miss Love doing unrecorded interviews or debates or discussions, say it as you will, but that's not the issue here. The issue is that she presented it to court in her rebuttal after cross-examination of Miss Bennett. So that is why this applies. It's not maybe directly, but it is a Georgia case that applies the words unsworn witness. But that is just a support of all the others, in my opinion. However, this strained proposition finds no support in Chambers or any other Georgia decision of which the undersigned is aware. You see how she focuses on Georgia? You know why this is so rare in Georgia? Because nobody was so stupid before. This might be a Georgia de novo, as in this is the first time a judge has to make a ruling on it. Chambers has nothing to do with the unsworn witness rule. As such, Williams' citation is unavailing. More than this, the fact that Williams fails to cite a single Georgia decision in which a prosecutor was disqualified on the basis of purportedly violating the unsworn written rules is, to say at least, telling. I agree. It is telling. It is telling as nobody was this stupid before until Miss Love. As far as the undersigned is aware, the only Georgia case in which a prosecutor potential status as a unsworn witness was even at issue is Bonner v. State. In Bonner, as here, the prosecutor cross-examined the witness about statements the witness has made to the prosecutor. False. In Bonner, as here, the prosecutor cross-examined. This was not cross-examination. This was rebuttal. This is the state's own witness. So the state cannot cross-examine their own witness. They do direct examination. The defense does the cross-examination. The prosecutor does the rebuttal. So she's off the mark already. Further, much like in this case, the prosecutor in Bonner continued cross-examination of the witness by calling to the witness mind the time, place, and circumstances of the conversations, as well as asking the witness point blank whether it was true that the witness had made certain statements to the prosecutor. As here, the witness was allowed to answer. Here's the difference, and let me show you. Because I have Bonner v. State right here. Let's see here, so you can see it properly. You can't. Let me go out here. I hope you can see it somewhat. Bum, bum, bum. And what she talks about is down here in the third part of the decision from 1989. The transcript reveals in regard to appellant's final enumeration that after appellant testified on direct examination that she had not visited the victim's bedroom, blah, 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 blah. The district attorney called to appellant's mind the time, place, and circumstances surrounding the conversation, in which the appellant was asked whether she told the district attorney that she went back into the victim's bedroom to listen to the radio. Now, the difference here is Ms. Love made a good portion, a big portion of her rebuttal about personal conversations she had with the witness. This Bonner v. State is one question and one question alone. And what the prosecutor did there in its cross-examination, not rebuttal, cross-examination of defense witness, was at this time, at this place, did you tell me something of this sort? The prosecutor didn't, here is what I said, didn't you reply like this? And if you remember from last week, what caused all of this is, what was it, 20, 25, 30 minutes of Ms. Love reiterating a conversation she had with the witness. What Fani Willis tries here in her speech or her opposition is to claim these are the same. And as I just told you, no, they're not. First of all, as I said, not cross-examination, because this is the state's own witness. And it was one question, very narrowly tailored. Ms. Love's questions for 15, 20, 25, 30 minutes, it doesn't apply, in my opinion. At this point in the trial in Bonner, defense counsel interposed an objection based on the district attorney's status as an unsworn witness, which the trial court overruled. One question, narrowly tailored. One. Not 50, not 20, not 75, one. On appeal, the defendant enumerated this as error. However, the Georgia Court of Appeals held that the prosecutor, having laid a proper foundation for the questioning and having allowed the witness to answer as appropriate, was not required as the cross-examiner to prove the making of the witness statements. The cross-examiner. See the difference here? And this is the central part of Ms. Willis' argument, to not have Ms. Love either removed as a prosecutor or to cause a mistrial. In my opinion, this should give the judge only two options here. Either remove Miss Love or mistrial due to prosecution's misconduct. But, as you all know, Judge Glanville, if he can find a loophole, he will. So I am not too confident about what will happen. I can say what should happen, but I cannot say it will happen, not by a long shot. And because, as I said, it's Judge Glanville presiding. And if he can find a loophole, he will. Okay, that's it. I don't want to read more of the garbage Miss Willis have presented to the court. So we will see more tomorrow about this, because tomorrow it will be oral arguments. And that I will live stream. Okay. Thank you all for showing up. Remember, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay. Bye-bye.